Members will be in their chairs. The chair recognizes the majority leader.
Thank you, Speaker. Members of the House, I move the House resolve itself into a committee of the whole for the purpose of a subject matter hearing on government operations as of July 1, 2015. The hearing will be conducted under guidelines established by the Speaker.
You heard the lady's motion. Mr. Sandak is recognized.
Thank you, Mr. Speaker. I was hoping to be recognized prior to the lady's motion. I rise on a point of order. Pursuant to House rules, I move for discharge of House Bill 4225 from the House Rules Committee.
Mr. Sandak, we're in the middle of order of business. We'll get to your motion, sir. We're in the middle of a motion. All those in favor of the lady's motion say aye. Opposed, no. The ayes have it. The motion is adopted, and the House hereby resolves into committee of the whole. Is there leave for the attendance roll call to be accepted for purpose of establishing a quorum in the committee? Leave is granted and a quorum is established. Representative Lang is appointed as the chair of the committee of the whole and is recognized to conduct the hearing in accordance with the schedule established by the Speaker. The committee of the whole will be in order. Representative Lang in the chair. Ladies and gentlemen, it's the 30th of June. We face an imminent shutdown of state government. We didn't have to be here. The governor has used the opportunity of the budget negotiations to discuss non-budgetary political issues over negotiating the budget of the state of Illinois. But even with that, the governor didn't need to go to the point of vetoing every single budget bill other than the education bills that we sent him. He didn't have to put us on the brink of a shutdown. In fact, he had two options that he didn't take, which would have kept state government open and not required that we be here today to go through this exercise. First, he could have signed the budget bills, and if he felt they were out of balance, he could have just simply not spent the money. As we all know, a budget bill, an appropriation bill, is simply an authority to spend money. It's not a requirement, and so the governor always has the power not to spend the money. So he could have brought anything he thought was out of balance into balance that way. The second thing he could have done, of course, was a reduction veto. He could have reduced those budgets any way he wanted by the stroke of a pen, and they would have instantly become the budget for the state of Illinois until and unless this legislator overrode those vetoes. But he chose not to do that. He chose to politicize the budget process. So today we meet as a committee of the whole to go through what this imminent shutdown of state government means. What does it mean to state agencies? What must they do? What preparations have they made? What will they do to make sure essential services move forward? In fact, what can they do? without an authority of this legislature and a signature by the governor to move that forward. Some will say, for instance, Mr. Sandak, that this is another dog and pony show, a sham, which is what he's been saying for weeks about our budget negotiations and our work on the House floor. But this, ladies and gentlemen, is not a discussion of the budget. This is a discussion of what we're going to do because we don't have a budget. This is something that all 118 of us in this chamber, all 59 in the other chamber, and every citizen of Illinois should have an interest in. What will we do come midnight tonight when we have no budget? And so to say this exercise today is not relevant is wrong. Nothing could be further from the truth. The people of the state of Illinois and we need to know what will happen moving forward starting at midnight tonight. Who will be hurt? What will we do to provide essential core services to the people that live in our state? Who will the state of Illinois get to pay? Who will we not pay? What decisions will be made and what criteria will be made to determine who will be paid in this interim time and who will not be paid? What state employees will be paid? The governor yesterday said, "Don't worry, state employees, we're going to pay all of you." Really? The Attorney General says, "Not so fast." The legal system says, "Not so fast." The Constitution says, "Not so fast." I don't know. There are narrow exceptions which may come out in this hearing, but we can't pay most of our employees without an authorization to do that. We can't pay most providers without an authorization to do that. We have a responsibility, ladies and gentlemen, as a body to figure out what comes next. And the administration has a responsibility to tell us what their plan is for what comes next. This hearing will help us understand that, not only in terms of providers of services and the clients they serve, but in terms of the plans by the administration. And so I, for one, look forward to these hearings so that we can figure out what to do together as a body. And for purposes of this hearing, it doesn't matter how we got here. This side of the aisle can blame one group of people or person. This side of the aisle can blame another group of people or person. But this isn't a budget discussion. This is the discussion about what to do because we don't have a budget. And everyone in this chamber should share an interest in the result of that. And so let us begin the hearing. The first witnesses are state agency directors. Each of these folks was invited 3 times or more by personal contact and by letter. And the beginning of this letter says to each of these directors, "Though clear differences exist in how to best serve the needs of the people of Illinois, we all share an obligation to provide those who rely on critical services with continuity of care and security. With that in mind, the House of Representatives requests your appearance before a committee of the whole on Tuesday, June 30th at 1 p.m. to discuss your agency's operating plan should July 1 arrive without a fiscal year 2016 budget in place. Therefore, I invite to the witness table the following agency directors: Department of Human Services, Secretary-Designate James Demas; Department of Health and Family Services Director Felicia Norwood; Department of Aging Director John Holton; Department of Public Health Director Dr. Narav Shah; Department of Children and Family Services Acting Director George Sheldon. Will these folks please step to the table? Once again, I will ask on the record, and I'm sure they're somewhere listening in the building or wherever they might be, Department of Human Services Secretary Designate James Demas, Department of Health and Family Services Director Felicia Norwood, Department on Aging Director John Holton, Department of Public Health Director Dr. Nirav Shah, Department of Children and Family Services Acting Director George Sheldon. Will these directors or designates please step to the witness table? Ladies and gentlemen, let the record indicate that none of these directors or directors designate have answered the call. None are at the table. None of these directors representing their respective agencies nor the governor's administration have appeared at the request of this body. They all received a letter and a contact from Speaker Madigan, and they have refused to attend this hearing today. With that, the next witness will be Heather Eagleton from the American Cancer Society, joined by Pam Luchtefeld. Mr. Sandak has a question of the chair before you folks proceed. Mr. Sandak.
Thank you, Mr. Chairman. I'm delighted you acknowledged me. One, would you favor your colleagues with a copy of the letter you've twice referenced? I've not seen the Speaker's letter to the people you've identified. Second of all, I'm looking at what was delivered to us 20 minutes before today's proceedings, and the people on panel one are none of the people that you just did that very dramatic call for witnesses. How were we supposed to, or how was anyone supposed to know who was to be called when panel one has Dr. Shaw, Ms. Eagleston, and Mr. Luchtenfeld as the designated witnesses? Would you be so kind as to address those questions, sir?
Well, for one, Mr. Sandak, we'd be happy to provide you a copy of the letter.
Thank you.
As to the other, I intend to name those directors in front of each panel. So for this panel, for instance, Dr. Shah is not present, is he?
Sir, you didn't call Dr. Shaw, but Tim Newting from the administration is here and is willing to answer questions for this panel and discussion.
Mr. Newting will be at the table after this panel.
So he is now acknowledged as someone that will be called as a witness?
I've acknowledged to you, I'll do it a second time, that Mr. Newting will be on after this panel.
Thank you. I appreciate that. And so will the next panels be in any numerical order? The sheet that you gave us has an order of proceedings. Do you expect that we'll follow that, or will there be some other people that will show up?
We're going to follow that list, but the chair reserves the right to continue to wonder where the directors are when they've been invited to appear before the House of Representatives.
You can wonder aloud, I'm certain you will, and I'll look for that letter showing me that you've invited them with ample time to attend today's hearing. Thank you, sir.
No problem, sir. Ms. Eagleton, you may proceed. Thank you for your patience.
Thank you. Good afternoon, members of the committee. My name is Heather Eagleton. I'm the Director of Government Relations for the American Cancer Society Cancer Action Network. Thank you for the opportunity to speak with you today. More than 10,000 Illinois women are expected to be diagnosed with breast or cervical cancer in 2015. This alone should be enough reason to protect the Illinois Breast and Cervical Cancer Program, or IBCCP. But when Governor Rauner revealed his state budget proposal several months ago, it included a 71% state funding cut to the program. Now, a potential government shutdown threatens to halt operation of the program altogether, leaving thousands of women without access to life-saving screenings indefinitely. The governor's proposed cut would result in a 50% reduction in the number of women served through the program. Women who still lack health care coverage for critical breast and cervical cancer screenings, who rely on IBCCP's free mammograms, breast exams, pap tests, and cervical exams. But unfortunately, that's not the only threat to the program. It was also proposed to eliminate guaranteed access to affordable chemotherapy, radiation, and other cancer treatment for women diagnosed through the program. Currently, women diagnosed through IBCCP automatically qualify for Medicaid coverage for their cancer treatment should they need it. That will no longer be the case if Governor Rauner's proposal is approved. Can you imagine being uninsured, going through this program, finding out you have cancer, and then realizing you have no way to get affordable treatment? The whole point of linking Medicaid eligibility to IBCCP was to avoid this exact scenario. While more women will have access to preventative cancer screenings and treatments under the Affordable Care Act, adequate funding for IBCCP is necessary to continue providing benefits and services to women who will continue to be uninsured or underinsured because of affordability and other barriers. It is estimated that more than 75,000 Illinois women between the ages of 40 and 64 will be uninsured. These uninsured women are less likely to get screened for cancer, more likely to be diagnosed at a later stage of the disease, and less likely to survive than those with insurance. These aren't just numbers on the page. These are mothers, these are sisters, these are daughters, these are wives who will lose access to vital cancer screening and treatments if you cut funding to IBCCP. From 2008 to 2013, the program detected more than 2,000 incidences of breast and cervical cancer and precancerous lesions, potentially saving the lives of these uninsured women whose cancer would have gone undetected or detected at a later stage when cancer treatment is less effective and more expensive. I'm grateful to the Illinois General Assembly for already committing to protect IBCCP. It's my hope that as budget negotiations continue, you will continue to do what is right for Illinois women and pass a budget that protects this lifeline for cancer patients. I urge you to avoid the possibility of having this program be shut down because of a lack of a budget solution. Today, millions of cancer survivors are alive. That includes thousands who are able to say, "I'm alive because of the Illinois Breast and Cervical Cancer Program." I'd like to turn it over to Pam, who can actually say those words. Thank you.
Thank you. My name's Pam Lichtenfeld. I'm from Decatur, Illinois. I am a breast cancer survivor thanks to the IBCC program and their ability to give me the treatment for my breast cancer. I appreciate the opportunity to talk with each and every one of you and share my story. I hope that that you will fund both the IBC treatment fundings fairly so that it can continue to help women like me and save lives. I have many in my family that suffered from cancer. This past summer, I dropped a box on my chest at work and blamed the lump from that box. I thought it was just a lump until it never went away, and it seemed to grow and grow until I didn't have money to go to the doctor, and I was unable to work because of it. And I was also taking care of my brother that had cancer. It had been 8 years since I'd had a mammogram, which I got from the IBCCA. But some reason I thought the program had been, thank you. But I thought the program had been discontinued. My friend told me that they still are there and offered it. So I got a hold of the IBBC in Springfield, and I got a hold of Heather, and she got a hold of so I could get a mammogram in Decatur. It was in September. The next day I went to have an ultrasound, and then the next day I went and had a biopsy. And then shortly, 2 days after that, I was called and said I had breast cancer. That was September 16th, 2014. As a result, they worked me right in, and I was able to quickly see Dr. Graham, who performed my lumpectomy, and I just recently finished my chemo and radiation through the Cancer Care in Decatur. Excuse me. I was able to get the services I needed without delay, thanks to the patient navigation from the IBCC staff and treatment possible through the IBCC program. I understand that you have very difficult decisions to make, but I represent the thousands of women in Illinois that are not insured, that are not still insured, and suffer for these programs that are not fairly maintained. And I want to thank you for listening to me today, because if it wasn't for this program, I probably wouldn't even known that I had cancer. But through this program, as of May 21st, I'm cancer-free. Thank you.
Thank you very much for that testimony. To Ms. Eagleton, I have a series of questions to ask you. Has the state agency that provides you with your funding provided you any direction in the event a budget isn't in place by July 1st?
They have not. We have reached out to them. The American Cancer Society obviously has staff that work in all the health systems, and we want to help get the word out and educate people on what would happen should the program be shut down or reduce services. I'm assuming that services would be reduced because the program does receive some federal funding. We get $6 million in federal funding, so I don't know whether that means they would use that funding as a stopgap. I'm just unclear. We have reached out to them, though.
And you've received no answer?
No, sir.
So would it be fair to say that the agency hasn't told you one way or the other if you'll get paid for services beyond July 1st?
Yes.
In what way, if any, has the administration committed to you that you'll be paid for services despite there being no appropriation authority?
Well, to be clear, the American Cancer Society isn't a lead agency for the program. We're just an advocacy organization, but we do work closely with the lead agencies and with the department. We consider them partners. So I'm not sure. We have reached out to several of the lead agencies to ask if they have received word from the department on what the plan is moving forward, and they have not.
Are you planning, or any of your member agencies planning, to reduce staff or services that you provide until you have clarity on the budget resolution?
I'm not clear on that, but I would imagine if I was running a lead agency and funding was vulnerable, that you would probably have no choice than to lay off staff.
And can you give us some broad strokes of what that would mean to your individual clients, those kinds of budget cutbacks or employee layoffs?
I would imagine it would lead to long waiting lists for women needing services, and what they would probably move to what is considered priority lists. So women that are presenting with lumps and symptoms, they would probably try to get them screened. That I would imagine, but I'm not 100% sure.
Has the agency advised you or any of your members whether you'll be authorized to continue to provide services beyond today?
Not to my knowledge.
And can you give us an estimate of the number of people serviced by your member agencies that would be impacted if the agency is unable to pay for services?
I don't have those numbers, but I would imagine it would be several hundreds, hundreds of women that are waiting to be screened. And our data shows that there's 75,000 women that would be eligible for the program that are uninsured in Illinois. Obviously, the program doesn't serve nearly that many women. I think the number for this year is like 23,000 per year.
And can you estimate for us, if you know, what dollars might still be due and owing relative to the current fiscal year we're in, fiscal 15?
That I do not know. Sorry.
Thank you. We've been joined at the table by Tim Newting, Director of Bureau of the Management and Budget, and the Governor's attorney, Jason Barkley. To Mr. Newting, Has DHS developed a plan in the event there isn't a budget in place on July 1st for American Cancer Society and other such agencies?
Thank you, Mr. Speaker, for the question. First of all, the Breast and Cervical Cancer Program, of which Ms. Eagleton speaks, is a Department of Public Health program. The departments have been advised. We've been working with departments for the last 2 to 3 weeks, if not longer, on contingency plans for a myriad of contingencies depending on the outcome of the budget that the legislature decided to pass. In this instance, we still believe we have 2 possible contingencies. One that looks very clear, which is entering July 1 with no appropriations in place. Another, I believe the possibility still exists that we may ultimately be delivered a budget that's $4 billion out of balance, identical to the one that the governor vetoed just a few days ago. We have been meeting with departments. We have advised departments to be communicating with their vendors. So I can't comment specifically on communication with the Cancer Society, but agencies have been advised to communicate with their vendors and with their grantees to talk through issues, to talk through the steps going forward in the instance that we don't have a budget. So those communications should be ongoing.
Well, I appreciate the answer, but with all due respect, I did not get an answer to my question. The question is not what you've done relative to the issues you raised. The question was whether you've developed a formal plan in the event there isn't a budget by midnight tonight.
Yeah, the plan in terms of planning with the agencies is to try and make sure that we are able to provide services for critical services initially. The things we're looking at first and foremost would be, education, which the governor signed that budget. We're looking at 24-hour care facilities where you have DD facilities, our prisons, making sure that our prisons are functional so that the public safety is preserved. Other grant programs, DCFS programs, DCFS is moving forward with those programs. So we're working individually with agencies to make sure that those critical services are up and running, and each agency then is working forward on their own to determine how to move forward at that point.
Well, at this point we're talking, and I misstated before I said DHS, we're talking about the Department of Public Health budget. The director is not here. You are here in his place. What plan does the Department of Public Health have starting at midnight tonight to fund those essential services without an appropriation?
Like every other agency, Mr. Speaker, they will be communicating with agencies, as the governor did, and employees, that employees should report to work. Everyone is expected to report to work, and they can expect to be paid. We fully intend to pay them and will pay them. With respect to grantees, they move forward with most grant programs, with the exception of those grant programs that we have already announced management actions on. So over the last couple of weeks, my office has announced some measures to begin managing what would be an out-of-balance budget by $4 billion. We have announced some measures that we would be taking, so obviously those measures that were announced publicly, we will not be moving forward on. And then we will be reviewing other programs on a case-by-case basis, and agencies will be taking the lead on that to try and implement those programs. I would say, Speaker, further, that it is our intention, and I know the word shutdown has been thrown around a lot, and I think it's used, frankly, cavalierly in order to scare people. But we are going to try and manage this thing as best we can. Payments will continue to go out to vendors for costs incurred in FY15. So many vendors who are unfortunately and have habitually been paid late will continue to receive payments until FY16 costs are incurred and those payments come due. Then obviously without appropriations in many cases, we would not be able to make those payments. But we're going to try and manage through this as best we can in the environment that we've been presented with.
So, Mr. Newting, I heard you talk about what you hope to do. I heard you talk about meetings with departments, but you don't have a formal written plan of attack for that you would implement starting at midnight tonight for any state agency. Is that correct?
Speaker, I hope you can appreciate that our agencies are very busy. The end of the fiscal year is a very busy time. These are extraordinary circumstances. They do not have a budget going into the next fiscal year. They are working very hard to manage their agencies, to work with their vendors, to work with their employees. So we have not had them hunkered down writing written reports. No, we are asking them to manage to the best of their ability and move forward.
So you indicated in your comments, Mr. Newting, that you were going to pay state employees that they should come to work and they would be paid. How do you propose to do that without an appropriation?
I'm going to turn that one over to General Counsel Jason Barkley.
Mr. Barkley.
Well, good afternoon, Mr. Speaker, members, Leader Durkin. Thanks for having us today. We recognize that there's concern about how employees will be paid without a budget, and I've been asked to address those concerns. Let me start by saying I think we agree on one thing, which is that state employees work very hard, they provide critical and essential services, and they deserve to be paid in full and on time for the work they perform. That is the right answer. We believe that is the equitable answer, and we also believe that that's what the law requires. And let me explain why we believe so. 8 years ago, we faced a similar situation. The Illinois Attorney General, on behalf of the Illinois Comptroller, reached an agreement with AFSCME at that time to ensure that state employees would continue to be paid during that budget impasse. That budget impasse is similar to the one we face today, and the agreement that they reached resolved pending litigation over the issue and resulted in an agreed court order. That agreement recognized, as the Attorney General still recognizes today, and it's our own legal conclusion as well, that the state's failure to pay its employees would violate federal law, and it could result in the award of double or triple damages, plus interest and attorney's fees to our state's taxpayers. It has been pointed out that when the court entered that order, the agreement, it said that this was not precedent. That legal term of art means that the order is not binding on a subsequent court, but that order nonetheless can and should be considered by subsequent courts. And it is especially instructive here, we would submit, Mr. Speaker, where the legal issues and the facts are nearly identical. Nobody has asserted, to my knowledge, that the 2007 order was unlawful then or now. The Attorney General got it right in 2007, and there's no reason that model does not work today. There is a path forward to get state employees paid on time and in their full amount. The legal issue, Mr. Speaker, is that the federal law that's at issue is the Fair Labor Standards Act, or the FLSA. It says that any employer, including the state of Illinois, must pay its employees at least the federal minimum wage and must pay hourly employees time and a half when they work more than 40 hours a week. When the Attorney General reached her agreement with AFSCME 8 years ago, she recognized two problems that prevented easy compliance with federal law. First, the state's payroll records did not identify which state employees were covered by the federal minimum wage law, because who was covered or not covered was not a simple determination. Second, the state's payroll systems were not equipped to quickly reduce employees' pay to minimum wage. So rather than instructing agencies to knowingly violate federal law and subject taxpayers to enormous liability, the Attorney General rightfully agreed that the court should order the comptroller to pay all state employees to the full extent that the comptroller could not feasibly limit paychecks only to FLSA-covered employees and in amounts necessary to comply with federal law. Those circumstances are no different today. Both of the problems that the comptroller faced 8 years ago, she faces again today. It is simply not possible in a short time frame for the state to produce payroll records that identify which employees are covered by the federal minimum wage law. Nor is it possible in this short time frame for the state to transform its payroll systems to order the payment of only a minimum wage. The first problem is identifying which employees are covered by the federal minimum wage law. That law identifies 5 types of employees who are exempt from the law and who therefore cannot earn overtime pay. Those 5 categories are executive employees, administrative employees, professional employees, computer employees, and outside sales representatives. Now, you might think that some employees can be easily identified as exempt. Just look at their job titles, right? If the title says executive, administrative, professional, or computer, then they're exempt. The problem is regulations promulgated by the U.S. Department of Labor says that's precisely what we are not allowed to do as an employer. In fact, 29 CFR section 541.2 says a job title alone is insufficient to establish the exempt status of an employee. So to determine who is covered and not covered, an employer has to follow the position definitions that are set forth in those regulations. The regulations comprise 16 single-spaced pages, and many of the definitions leave room for discretion and subjectivity. So let me read just one part of those for you to explain the problem that the employer faces. An administrative employee is defined as one whose primary duty is the performance of office or non-manual work directly related to the management of the employer. That definition could cover a wide swath of state employees. But directly related to management, that defined term is further defined to mean the performance of work directly related to assisting with the running or servicing of the business, as distinguished from, for example, working on a manufacturing production line. That definition doesn't give us much help or guidance, especially as to state employees. My point is simply that the state cannot, in short order, identify which employees federal law exempts as administrative employees. And the same principle holds true for other categories of employees. The only way to make those determinations is to review each position one by one, determine what duties each employee in that position actually performs, and then apply the U.S. Department of Labor's definitions to those positions. That has never been previously done by the state. And there has been no systematic attempt to designate state employees. To accomplish that for 50,000 employees, we collectively, that process would take many months, not days. The second problem, Mr. Speaker, is the minimum wage itself. Among its various agencies, the state government has at least 4 different payroll systems, and none of them are set up to accommodate a global change in hourly pay and benefits. The only way to reduce the pay of state employees to the federal minimum wage is to adjust each employee's pay manually. That cannot be done overnight and not in a matter of days. That is a software problem. That is a programming problem. More importantly, you cannot reduce an employee's wages without having far-reaching implications on other financial matters that are tied directly to those wages, which potentially implicates other state and federal laws. For instance, let me give you some real-world examples. The state employees' retirement system, for instance, will have significant problems handling a temporary reduction in earnings by state employees during the minimum wage period, as income history and earnings credits will be substantially distorted. There will be employees who are retiring during this period, and those employees will have permanent problems with their retirement benefit calculations. If employees are suddenly paid large amounts of back pay, it will result in huge income spiking that could complicate pension calculations at the end of one's career. State health employee insurance benefits can be distorted as a result of minimum wage laws, because those are indexed to employee earnings. State employee life insurance is indexed to employee earnings. And then think about all of our state employees who have bankruptcy payments, child support, tax levy garnishments. They may be able to not meet those minimum payments because of the automatic deductions they have set up in their payroll accounts. Similarly, employees with bank loans. So think about all of our employees have mortgages, car loans, student loans that are being automatically deducted from their paycheck. This could put them in default of those loans. And of course, there's the new minimum wage law in the city of Chicago, which adds an additional layer of complexity to how we pay state employees who work within the city limits. There's a second important principle that, Mr. Speaker, the body should be aware of, and that is that we agree with the Attorney General who recently articulated that the state constitution permits the comptroller to continue to pay for essential services in the absence of appropriations, or said otherwise, those obligations that have been statutorily mandated by the General Assembly. We also agree with the Attorney General's analysis that there's no uniform definition of essential services. And again, nobody in state government has ever attempted to analyze what that means. And that analysis must happen position by position and statute by statute. Furthermore, as an employer in a collective bargaining regime, we must include the union in any of those discussions. And as I've had discussions with the union, they confirm for me that they believe every position is essential. So it's not as simple as saying that we can shut down all non-essential employees overnight. That's not a realistic possibility. So as a lawyer who advises state agencies, we've advised them that the prudent, moderate course is to continue paying state salaries to provide these critical state services until such a process can be devised and completed. So to be clear, while there's been some misinformation that we may have other options about how we process payroll, I simply say to those folks that we respectfully disagree. To fully comply with state and federal law without the risk of significant financial penalties under the FLSA or critical service interruptions that have been statutorily mandated, we must continue to process payroll as we always have. Thank you, Mr. Speaker, and thank you again for inviting us.
Mr. Barkley, I appreciate your comments. A couple of questions about those comments, and then we'll move on to another issue for you gentlemen. So you referred to a 2007 case, and you indicated that was an agreed order, and that the order itself indicated that it was for that case only. Is that correct?
That's right, Mr. Speaker.
And you indicated that the Attorney General at that time was in full agreement with what happened there and was a signatory to the agreed order. Is that correct?
Well, that's my understanding. My understanding is that they appeared in open court. I think you're aware that the ethical rules that apply to attorneys don't allow them to stand up and represent that they believe the order they're entering is unlawful. So it's certainly my assumption that they believed so when the order was entered.
And the Attorney General at that time was Lisa Madigan, is that correct?
I believe so, Mr. Speaker.
And the Attorney General today is Lisa Madigan, is that correct?
Yes, sir. Yes, sir.
So you're aware that after the governor made his comments yesterday that he thought he would be able to pay all state employees their salaries, that same Attorney General announced, "Not so fast, Governor, you can't quite do that." Isn't that correct?
Well, Mr. Speaker, respectfully, that's not the way I read her statement. I think she said that she believed that payroll could actually be processed in this FLSA-compliant manner, and that if it could be processed in that manner, that the 2007 order wouldn't be appropriate. But we're telling you, and we mentioned to the Attorney General, to the Comptroller, that's simply not accurate. We cannot, for many, many months, produce an FLSA-compliant payroll. In order to stay in compliance with the FLSA, we must continue to pay our employees the full amount and on a timely schedule.
Did not the Attorney General also refer to the Constitution of the State of Illinois that forbids the payment of, in general, of money that has not been appropriated by the General Assembly and signed into law by the Governor?
And, Mr. Speaker, as you may be aware, the Supremacy Clause of the Constitution makes federal law supreme to the state constitution. And so the FLSA actually trumps that state constitutional provision. So we cannot be out of compliance with federal law without the risk of these double and triple penalties. And that's simply not a cost that our taxpayers should bear.
So you're suggesting that because it's impractical or difficult to determine who's exempt and who's not exempt, that the state of Illinois is obligated, if there is no budget and there is no appropriation, to pay everybody's full salary who's an employee of the state of Illinois?
We would submit, Mr. Speaker, that that's the lesson of 2007, that we must continue to comply with federal law, that is an obligation that trumps any state obligation, and that's the path forward to continue paying our hard-working state workers the pay they're rightfully deserved.
Are you suggesting it's too difficult for the Rauner administration to comply with federal law?
No, this is the path to comply with it. We're ready to comply with it. So we've indicated to everybody that we can comply with federal law in this manner, and that's how we would like to proceed.
Actually, it's not what federal law says. You've indicated the federal law says there are exempt and not exempt employees. You've just indicated that you can't determine who's exempt or non-exempt. So even though the Constitution of our state requires an appropriation, you're prepared in the case of no appropriation and no signed budget to pay every employee their full salary. Is that correct?
I just wish there was a way to comply in that narrow fashion. But rather than putting us out of compliance and subjecting taxpayers to these enormous financial penalties, we simply want to borrow the same model that was used in 2007, that the Attorney General blessed, the Comptroller blessed, a state judge blessed. It's a really, very, very simple, straightforward process that we would like everybody to embrace as well.
So while we recognize that the Supremacy Clause says that federal law is more important than state law or supreme to state law, is it the Rauner administration's position that the Constitution of the state of Illinois ought to be ignored because it's too complicated to comply with the federal law?
No, again, respectfully, Mr. Speaker, that we agree with the Attorney General's analysis that the state constitution requires essential employees to also be paid their full salary and on time. So that's a state constitutional provision that allows payment of those salaries in the absence of an appropriation. So we respect both federal and state law. This path forward, using the 2007 order, is the best way to do both of those things.
So isn't it a fact, sir, that even under the federal law you cite that people should be paid not their full salary, but federal minimum wage?
The law says that they need to be paid at least their federal minimum wage. We're telling this body that we are unable to do so with our current pay systems. They are so antiquated and we don't have the processes in place. The only way to pay employees any amount of money is to continue to pay them their full amount and on their current pay schedule.
Have you made any effort to go to the Attorney General as the chief law enforcement officer of the state and have them help you determine who is or who is not covered by federal law?
Yeah, we have not done that, Mr. Speaker.
Wouldn't it have been prudent to get some help in this regard?
We've got some really qualified attorneys in state government who are looking at this issue. We've met with the Attorney General's office to understand their position on this issue. And again, we're trying to sort through the immediate issue, which is how do we process pay. The second step in that process is then, well, how do we set up a process to determine who is FLSA exempt, who is FLSA covered? How do we get our pay systems to pay minimum wage without disrupting state employees' pensions, health insurance, life insurance, bank loans, auto loans? So this is a very, very tricky legal question. It's a tricky practical question. We're in stage one of finding the path forward. And unfortunately, obviously there are those who disagree with this path. And we, again, respectfully disagree with those folks. But if we could reach agreement that this 2007 order was the model, then we could move on to this second stage of figuring out the logistics of how we accomplish it.
So we're all interested in paying state employees, but we don't want to do it at the risk of violating the Constitution of the state of Illinois. Let me ask you if you've considered a declaratory judgment action so that we would have an answer to this question before midnight tonight.
Mr. Speaker, of course, the Attorney General represents the state in all litigation, so that would have to be a question directed to them.
Can you repeat that answer, sir? I'm sorry.
Yeah, the Attorney General represents the state of Illinois in all litigation matters.
Have you asked the Attorney General to get clarification from a court on this issue?
Well, we've asked them for their opinion on the issue, and again, I think you read the same opinion that they provided to us, and that it contains a factual error, which is this assumption that we can somehow produce an FLSA compliant payroll. That's not accurate, and in fact, it would take many, many months for us to do so.
And so then it would be your position that under no circumstances, because of the size of the state payroll, could we ever determine who's exempt or not exempt under this federal law, or whether it's this state or any other state, every employee would have to be paid under your analysis. Is that correct?
No, Mr. Speaker, with all due respect, again, I think we can do it. It just will take many, many months to do so because we have to go position by position, look at every job description, look at every job responsibility, and potentially discuss those issues with the union and others So it can be done, and frankly, it should have been done years ago. But again, it was one of those things that we were handed when we took over as an administration that needs work, and unfortunately, it's not been done by this budget impasse.
And so it's too impractical to do, and therefore, because you can't find a way to comply with the federal law appropriately, you've chosen the federal law over the state constitution. Isn't that correct?
No, Mr. Speaker, again, with all due respect, we want to comply with both federal law and the state constitution, and we do believe there's a way to fully comply with both. That's to continue to pay payroll as it currently exists, which is the model from 2007 that the Attorney General sanctioned, the Comptroller sanctioned, and a state judge sanctioned, and also continue to pay essential employees their full salaries and on time for those services that are statutorily mandated. We believe that would accomplish your goal, my goal, of complying with both state and federal law.
Let me move back to Mr. Newting. Sir, are there any specific consent decrees or court orders that mandate state government to continue to provide specific services regardless of appropriation authority?
Yes, Mr. Speaker, there are, and if I could comment on the back end of General Counsel Barkley, I would like to note that I find it ironic that we are talking about the constitutionality of whether we pay employees or not, a question that only arises because of the violation of the Constitution that your unbalanced budget provided. Consent decrees, there are many. We have asked agencies to look at those. Again, in concert with Counsel Barkley's office, we have communicated with agencies. It is part of the prioritization of services that we are looking at with agencies. We want to, one of the priorities is to have these agencies continue to do their best to be compliant with consent decrees, and they are moving forward in that fashion.
Do you have a list of those consent decrees today so that we can determine what services as a General Assembly we need to make sure that we can provide and the dollar amounts attached thereto?
I don't have those with me today, but we certainly could provide those. I assume that your staff is as familiar with those as our staff is, but we'd be happy to provide those.
Do you have that complete list, sir, even if not with you?
No, sir. I did not bring the list of consent decrees today.
No, that's not what I asked. I asked if you have that list, whether you brought it with you or you did not bring that with you. There is such a list, is that correct?
That is correct.
All right, and it's been fully compiled, so you said you've talked to the various state agencies. I just want to make sure you have all the information.
Yes, if you have information you'd like to give us, we'd be glad to accept it.
All right, and so when can our staff expect to get that list from you, sir?
Okay, so you're telling me you don't have the list of consent decrees on your staff? Okay.
We would like the list that the governor's office has so that we can compare it to whatever we might have available to us, so that we're speaking from the same hymn book, sir.
Okay, we will forward that at our earliest convenience.
Thank you. Are there any other services other than what might be in those consent decrees that you deem to be essential for health, safety, and welfare that various state agencies must provide?
Well, again, the priorities are 24-hour care for individuals we have many facilities that provide 24-hour residential care. We certainly want to make sure that those services continue. That would encompass everything from the state prison system to developmental centers to mental health centers to Medicaid services must be provided for nursing homes to veterans homes that we administer. So those are obviously high priority spending items that we have directed the agencies to fund. Continuing appropriations, areas of continuing appropriation that you have by law required certain things be paid. Those things have to be paid, so those will continue to be paid. That would include things such as pensions, pension payments, which will be made. Debt service, of course, always has to be made. And strangely, General Assembly pay and General Assembly budget pay.
So that was a very general statement. So the question was, are there other services? We'd like a list from the governor's office as to what services you deem as essential, and so that we can assess them. We'd also like to know, if you don't have spending authority, what services do you anticipate will continue without spending authority, and how will you pay for those?
Yeah, we do not have a complete list of that at this point. Again, we are working with agencies. We have not drafted that up. We are trying to manage through this as best we can, and we will continue to communicate with your staff in regard to the actions that we are taking. I think, Mr. Speaker, frankly, throughout this process, beginning in February, I feel like we've been open and transparent. We've appeared in front of your committees many times. We've communicated with your staff. We've provided reports upon request, so we will continue to work with you and be transparent about what we intend to do.
Nevertheless, this is an important and critical question for state government at this point. Midnight is approaching. So we need to know, as a General Assembly, I'm not just speaking for the majority party, the members of the General Assembly need to know exactly what services you deem as essential. Surely you've had time since January to figure out what that list might be, and we want to know how you're going to pay for that list of essential services given no spending authority.
We have done our due diligence, and we have met with agencies, and we are going to do our best to make sure that services continue and that we are able to manage without a budget or with a $4 billion unbalanced budget that your body has presented to the governor. I mean, frankly, Mr. Speaker, we're playing on your playing field. You're the appropriators, we're the administrators.
Well, that's correct, but the governor's office indicated they want to continue to pay for essential services, and it's important for us to understand what the administration feels is an essential service. So I would ask you formally to provide that list to us along with the dollar amounts. Separate and apart from what those items might be, how do you propose to pay for those items, whatever they are, without spending authority?
Well, the idea is that ultimately there will be spending authority, so we will continue to provide services, and vendors and grantees will be advised that we don't know when they will be able to be paid, but eventually they will be paid. And of course, for FY15 services, paychecks and grant payments and other payments will continue to come to vendors and grantees. Once we get into FY16 payments, we will have to hold those until we have the appropriate appropriation authority from the legislature.
And so you would say to all the grantees, trust us, we'll get back to you, just keep providing services, tell your employees, just wait, they'll eventually be paid. And with the track record we have had, you want us to tell grantees, just sit around and wait, maybe we'll get back to you?
Well, I'm not going to defend your track record, but we are putting in place contracts with vendors and grantees, and if we have a contract in place, we will pay it. We are legally obligated to do so. So eventually they will be paid. And I would say clearly this is less than an ideal situation, but this is the situation that you've put before us, and we intend to manage it to the best of our ability.
Aside from the court orders and the continuing appropriations and the contracts that are already in place, without spending authority, how does the Constitution allow you to write any checks to anybody?
Again, I'll probably defer to General Counsel Barkley on that, but very ironic that we're having this discussion because of the unconstitutional budget that you passed.
Are you a lawyer, Mr. Newting?
No, sir.
So we'll leave what's unconstitutional to the lawyers.
Are you arguing to me, Mr. Speaker, that your budget was constitutional?
The governor vetoed the budget. He had many other options, which we will get to in a minute. Does
No,
Mr.
sir.
Barkley have an answer to the question as to how
he
you're
had
going to
no
pay,
options.
how you're going to write checks without appropriation authority?
He had no options. It was an unconstitutional budget. It deserved to be vetoed.
Well, sir, first of all, you're completely incorrect. And so Under our law, I don't want to give you a lesson, but I think you know the answer to this. Under our law, the governor had two other options. One was to do a line item or reduction veto, and the other one was just simply sign the budget and not spend the money. You know that. So don't come to this committee of the whole and tell us otherwise. The governor had other options that would keep state government open without the need to go through this exercise or the need to spend the summer and the fall debating this budget. So my next question's for Mr. Barkley. How do you propose to pay anyone without spending authority?
Well, let me address the first point, which is the unconstitutionality of the budget. You may be aware, Mr. Speaker, that Leader Durkin and others sought an informal advisory opinion from the Attorney General in fiscal year 15 that indicated that the fiscal year 15 budget was unconstitutional if it was unbalanced. So the Attorney General has issued an opinion saying that it would be illegal, it would be unconstitutional to pass an unbalanced budget. To your specific question about how we pay going forward, again, I think Mr. Newting has outlined the path forward, which is we believe we can continue to pay state employees their full paycheck and on time, and they continue to provide state services. There are certain statutory appropriations that exist that are legal to pay in the absence of a state budget, and the Attorney General has outlined this theory of statutorily mandated obligations that allow us to pay certain obligations as well. So there are certainly certain services that can continue to be paid in the absence of a budget. We intend to do so. And then, Tim and his team are doing a terrific job of managing, in the absence of appropriations, to keep all the lights on across state government.
So aside from state employees who you think you can pay, and I'm not quite sure, and aside from consent decrees and prior obligations of the state of Illinois, how do you propose to pay, to actually literally write the checks for what you feel are essential state services without an appropriation?
We won't write those checks until we have the appropriation to do so, but we will put the contracts in place to provide those services, and in many cases, our agencies have years of partnership with these grantees and with these vendors to work on these items to make sure that they continue to provide service knowing that they will eventually get paid. But you are correct, Mr. Speaker, that outside of continuing appropriations and the payroll issues that Mr. Barkley has discussed, and potential court orders on consent decrees, we cannot write checks, and the comptroller will not cash checks until we have the requisite appropriation authority from the legislature.
Have any state agencies authorized some providers to continue operating specifically on a promise that they'll eventually be paid?
Yes, sir. That is happening all over the place. As an example, Department of Children and Family Services, which we believe provide critical state services, are working with their vendors to put contracts in place so that there is no interruption in state services.
Were there some that were told not to continue operating?
Yes, sir. Any programs that we have notified the public and the agencies that we will not be funding going forward in this environment will not be offered contracts at this time. We reserve the right later, after a budget is finalized, to revisit those, but there are those at this time, and those have been, for the most part, announced publicly.
Do you have written criteria for determining who the winners and losers were moving forward?
No, sir. As you can expect, these don't fit nicely into neat boxes. These are difficult decisions. There's a lot that goes into them. There's a lot of gray area in state government. This is not a situation we wish to be in, but we will manage it to the best of our ability.
Talk to me, please, about the use of non-appropriated funds. I'm aware that some of your agencies have access to non-appropriated funds. How will they be used?
Yeah, there are non-appropriated funds out there. I think because they are non-appropriated, I believe that they do not need appropriation authority to move forward on those. Candidly, that has not been at the top of our list of things to review. It has not been a high priority, but we do have someone looking at non-appropriated accounts. In the grand scheme of things, they're not extremely large. Some of those non-appropriated accounts, for instance, I think income tax refunds and unemployment insurance payments, we will continue to allow those agencies to move forward with those payments.
And how do you intend to use the funds?
Well, we would use the income tax refunds are paid to those folks that are owed refunds based on their taxes. We don't want to hold those up. We believe we have the authority to make those payments, and we will do so. Unemployment Insurance Trust Fund is a non-appropriated account, I believe, and we will continue to make those unemployment insurance payments as well.
Have all state agencies instructed employees under their charge to report to work?
Yes, sir, as well as the governor's notification to all state agencies, I believe it was yesterday, that all state employees are expected to report to work, and we expect that they will eventually be paid in full.
Have any agencies advised any employees not to report to work?
Not to my knowledge. If you know of any, please let me know.
Has there been any estimate made of the cost to state agencies if there's a reason to totally shut down and then to restart? What would the cost of restarting state agencies be if there's a total shutdown?
Well, first of all, there's not a total shutdown, so there will be no cost to restart state agencies. But I would say that the fact that the legislature did not reappropriate many capital projects has resulted in us having to effectively tell people in mid-construction that it would be prudent for them to stop operating because we would not be able to pay their bills post July 1. So in terms of capital, there will be some costs associated with those construction projects shutting down and with those vendors and contractors securing those sites. I don't know what that cost is. It could be exceptional, but again, that was not a decision made by our office. That was a decision mandated by the budget that you passed.
Mr. Newting, can you tell us, since you're here, why the governor chose to veto the budget bills rather than line item, reduce them, or simply not spend the money?
Yeah, thank you for that question, Mr. Speaker. And you are correct. There are technically other options for the governor, and this is kind of a little inside baseball, but you'll certainly understand this. The way that you structured this budget and the areas that you protected by law and the areas that you left exposed to management actions, the governor does not have the ability to manage the entire budget on his own. So as an example, debt service payments have to be made because of a continuing appropriation. Pension payments have to be made because of a continuing appropriation. You chose to protect Medicaid vendors, hospitals, nursing homes, doctors by locking their rates into statute. There is very little the governor can do there. You also chose to protect local governments, the RTA, and others that get statutory transfers out. So the $6 billion a year that we send to local governments, the governor has no authority to do anything to manage there. So effectively, what you've done with your laws is you've limited the playing field to about half of the budget. The items that I just mentioned represent over 50% of state spending. We have no ability to manage that. So we have to manage the $4 billion hole on the other side of the ledger, which leaves education exposed, higher education exposed, and human services exposed. For that reason, we chose to veto the whole thing and throw it back to the legislature to start over, with the exception of the governor's often stated #1 priority of elementary and secondary education.
Thank you, Mr. Newting. Mr. Zaleski.
This question is for Mr. Barclay. I'm way over here. Way over here.
Yes, sir.
Should I stand up? So my question is regarding the employee payments. There's a lot of people who are going to rely on what your testimony is here today, that they're going to get paid in the next month. And I'm probably not as skilled as an attorney as you are, but my understanding from the agreed order was that it came about as a result of just trying to move along from the veto, and I guess I'd ask that you elaborate on how a judge can be persuaded that after 8 years since the last time we went through this, the state's personnel records and state's efficiencies wouldn't have adjusted to know who gets paid this federal minimum wage or not.
Well, I've heard that you're a much better lawyer than I am, so you're too modest. I would just say that I was as shocked and disappointed as you were in hearing that news. We went through this 8 years ago, and that should have been the start of the process to identify these positions. But nobody in the previous administrations undertook that effort. So I'm deeply disappointed, like you are. But I guess the silver lining is it allows us the path to go forward to use the same 2007 model to continue paying state employees their full paychecks and on time. And that's something we should all embrace.
Would you anticipate that your lawyers would file the motion for a temporary restraining order or a preliminary injunction to get this paid?
No, and that's a really, really important point as well. So obviously we are one actor in a larger drama here, and it's the comptroller who must process the payroll, and she is advised by the Attorney General. And my understanding is that the Attorney General believes that the 2007 order that they entered is now unlawful. Yeah, we just respectfully disagree with that position. We believe that's the order that needs to be entered now to allow state employees to be paid. So you're going to need the agreement of the comptroller and the Attorney General to get state employees paid. The governor's message was simply this: we want to pay you. We want to pay you in full, we want to pay you on time, and there's a legal path forward to do so. So we would happily join with the comptroller, the Attorney General, and by the way, the unions asked me this morning, and I met, and they are more than willing to enter into an agreement with us over exactly that type of order. So unfortunately, we can't alone force the comptroller to do this, but we would obviously strongly encourage her to do so, and we would encourage the Attorney General to do so as well.
What happens if your advice to the controller is pay them under the 2007 order? The Attorney General's office advice is don't pay them. Who would the controller defer to?
Well, I think the comptroller gets her own legal counsel. She's not bound by my legal opinion. She's not bound by the Attorney General's legal opinion. She gets her own counsel, and I want to be clear that we're not telling anybody to comply with the 2007 order, which expired. What we're saying is that she should reach the legal conclusion that we have, that the Attorney General reached in 2007, that you may not be out of compliance with federal law. You don't need a court order. You don't need a judge to tell you that. There's a federal law that says that if you refuse to process payroll, states' taxpayers are going to incur significant financial penalties, and we should not put our taxpayers in that position.
Sorry, Mr. Barclay, just to be clear, you haven't had a conversation with the Controller's Counsel of what they would do in that instance?
We have had conversations. We've laid out our legal position, and I think they are considering our legal position. It obviously conflicts with the Attorney General's legal position. The Attorney General's got some good lawyers. They're very persuasive. I hope at the end of the day we're more persuasive.
Okay. Thank you for answering my questions. Thank you, Mr. Speaker.
Representative Gable.
Thank you, Chairman. So it's about IDPH and contracting. IDPH is mostly funded with federal money, and there are flow-through grants. Will those grants continue, particularly Title V and Title X grants that are predominantly federal dollars, but there are supposed to be some matching state dollars with that as well? And has the department set up contracts with the organizations that usually receive those funds, and will it be payable as of July 1st and paid retroactively?
So thank you for the question, Representative. First of all, on federal funds, it would be our intention to continue to the best of our ability with services out of those funds. I think on federal funds, we would plan to pay those eventually, and we would obviously, that's not part of the $4 billion unbalanced part of the budget. on federal funds. So we would look to do that. Any contracts that are established either there or in other places would definitely be established for July 1, and payments would be expected to be paid retroactive to July 1 for any services that were rendered during that time period.
And so you're not sure if those contracts were established or not?
No, I don't have individual agency contract information, no.
Okay. And are there some contracts that are being held back?
Yes. Again, those contracts for services or with vendors that the governor has previously announced in his management actions over the last couple of weeks that he announced those programs that would be suspended, we clearly will not be moving forward with those at this time. And those are all a matter of public record.
Okay, thank you.
Mr. Sullivan.
Yes, Mr. Chairman, I do have an inquiry, as you are the chairman of the Committee of the Whole. I was looking for one of the governor's liaisons to ask her a question, and it's been informed to me that they were thrown off the floor. Could you explain why we would throw the governor's liaisons off the floor and pull their credentials?
I'm told they were not thrown off the floor. They didn't have a pass. So once they have a pass, they'll be on the floor like everybody else.
And when you pull their credentials and don't give them the passes, the effect is that you've thrown them off the floor.
Well, I don't know that that's the case. Governor's liaisons have been on the floor every day, all session. There'd be no
Clearly.
reason to do that.
So I can tell them that they're welcome to come right back right now.
I will certainly have somebody look into that for you, sir.
To my friends on that side of the aisle, this is what this has come down to. We're going to be here a long time. September 13th is the Bears Packers game. I think they got a good bar here that we can go hang out, because that's how long we're going to be here if this continues.
Mr. Sandak.
Thank you, Mr. Chairman. Appreciate being recognized for some questions of Mr. Barkley and Mr. Nuding. Mr. Nuding, I think you were here when the chair did his prop type of call for the agency heads, bring down Ms. Norwood and so on. You're the governor's liaison and you're the governor's point person on the budget. Isn't that correct?
That is correct.
And as you sit here today, are you able to articulate with respect to anything having to do with the lack of a budget and what goes on going forward from the governor's office perspective? Do you speak for the governor's office?
Yes, sir, I do.
So should Mr. Lang decide to again call out names and hear himself, hear the echo of his own voice and see no response, you'll be prepared to answer any legitimate question with respect to the budget process and what goes on going forward?
Yes, I have been offered to provide testimony and answer questions regarding the budget.
And Mr. Nudie, I want to be clear on something here. I don't know if you have all day to sit here and go through this process, but I'm hoping that whoever has questions of you and or the administration can bring their questions, and I'm sure Mr. Lang will permit an orderly process so that we don't have you sitting here till 9 o'clock at night when you should be undertaking, frankly, emergency duties propelled upon you from the Democratic House members and Senate members that passed an unconstitutional, unbalanced budget.
Well, candidly, I cannot sit here till 9 o'clock at night. We have a lot of work to do on the last day of the fiscal year, and frankly, I was told that there was some agreement that Jason and I would spend maybe an hour here answering questions to the best of our ability. We're past that, but we're glad to stay a while longer to try and answer as many questions as we can.
Well, thank you. My next question is actually for Mr. Barkley, so that's a nice segue. Representative Lang asked an opinion. It was actually a rhetorical question because apparently he thinks the budget that the House and Senate, through a partisan vote only, sent to the governor was constitutional. Sir, do you have a legal opinion with respect to the spending plan? Because as I understand it, no new revenues were voted on by the Democrats that sent the spending plan to the governor.
Well, I'll simply respond by telling you what our own research is, and it started with looking at the Constitutional Convention, 1970, and then there's an Attorney General opinion from last year at the request of Leader Durkin and others as it relates to fiscal year 15 spending where expenditures were greater than revenues. And the opinion of the Attorney General's office was that that is unconstitutional, that the provisions of the Constitutional Convention do not allow that. And we agree with that analysis, that it would be unlawful for the governor to sign an unbalanced budget. And that was our advice, and we believe that in order for him to sign a budget, it needs to be truly balanced.
And so, you know, there's been, well, actually, it wasn't intimated. It was specifically said by the chairman on at least 2 occasions that the governor simply just didn't have to spend everything the House Democrats and Senate Democrats sent his way. Is that your reading of the Constitution?
Again, it's not my reading, nor was it the reading of the Attorney General.
Thank you, and I appreciate that. Mr. Newting, with respect to how we got here, you gave a little bit of inside baseball analysis, and frankly, I think it's instructive for members of this House, particularly folks that put votes on the unbalanced budget, to, I guess, reiterate how that unbalanced budget, despite, and obviously aside from its unconstitutionality, how it handcuffed, if the governor could have signed it, how that would have handcuffed his ability to manage state funds.
Yeah, so again, by law, there are many payments that are locked into statute that have to happen. Debt service, which has always been so, and I wouldn't quarrel with that. Pensions, the full pension payment must be made. Medicaid rates were protected for the most part. Payments to doctors, payments to podiatrists, payments to others, payments to hospitals were all protected. The governor has no discretion, or I should say very little discretion, in what he can do on hospital rates. Payments to local governments, the $6 billion a year that we pay out to local governments, to cities, municipalities, townships, mosquito abatement districts, water and reclamation districts, those types of payments. There is nothing in this budget the governor can do to manage that because it's all locked in by statute. So when you're faced with a budget with a $4 billion hole and somebody says manage it, after they've taken all of those items off the table, then you have to go to the areas where you have discretion left. And those areas are education, higher education, and human services. And those are the areas that are exposed by this unbalanced budget to management actions to try and bring it into balance. And I would say further, it's done by design.
You mentioned some of these required payments or where discretion isn't necessarily very great. We used to call those above the line type of expenditures. Would that be fair to say?
I've never understood that term. I don't think in budgeting anything should be above the line.
So with respect to what this budget, well, I'm going to call it a spending plan because I think that's what the Speaker called it. Let me make sure. You're not aware of any vote to fund the spending plan the Democrats handed this administration, are you?
No, sir. We are operating under the assumption that we will be utilizing the revenue that currently exists in state law.
So with respect to your, I guess, reiteration of how handcuffing the spending plan was, essentially they wanted the governor to make all the hard decisions the appropriators weren't willing to make.
If there's a list of $4 billion in cuts that the legislature would like to offer to us, we'd be happy to review it.
And as a reminder, it's the General Assembly's responsibility to appropriate and give a governor a budget, not vice versa.
The legislature are the appropriators and we are the administrators. We play on the playing field that is provided to us by the legislature.
There's been some nomenclature in the media about how the governor's budget would do X, Y, or Z. Are you aware of any governor's budget that we're dealing with right now?
No, sir.
And we're only dealing with the spending plan that the governor vetoed because it was out of budget, it was unbalanced, and was unconstitutional. Isn't that correct?
That is accurate.
And, sir, do you stand ready, willing, able, and frankly, right now, shouldn't we be talking about how to fund state government services and actually pass a balanced budget? Wouldn't that be a better use of our time?
Indeed it would.
Thank you, gentlemen, for your time. Sorry you're here.
Mr. Breen.
Thank you, Mr. Chairman. My questions are going to Mr. Barclay. Mr. Barclay, if you could just help me out here. I just want to make sure we're clear. The August 10th, 2007 agreed order, so it was an agreed order. That's an agreement between counsel for the state of Illinois and counsel for AFSCME, correct?
That's right.
Okay. Now, and the counsel for the state of Illinois is the Attorney General, correct?
Well, in this case, the comptroller was the party to the agreement, so the Attorney General represents that state constitutional officer in that particular court proceeding. That's correct.
And just under our law, and at least as I understand it, the Attorney General does not report to the constitutional officer they're representing. She actually represents the interests of the people of the state of Illinois, correct?
That's my understanding.
Right. So, so if the Attorney General doesn't report to the governor and entered into an agreed order to pay all of these states' employees without any further changes or claims, what's the difference between 2007 and 2015? Same Attorney General, same status of issues with the federal law. What's the difference?
Yeah, we've struggled with an answer to that question as well.
Might be that there was a Democrat sitting in the governor's chair and that now there's a Republican. Now, I do want to go to the issue of the Constitution as well. I just want to I don't see why there's a dissension on this, because the state Constitution, Article 8, Section 2, Sub B, the General Assembly by law shall make appropriations for all expenditures of public funds by the state. Appropriations for a fiscal year shall not exceed funds estimated by the General Assembly to be available during that year. And Counsel, I think you've alluded to this, but I mean, there really is no other, there's no alternative given to the governor by the state constitution but to veto the budget. Is there?
Not in our legal opinion. We believe that it would have been unlawful to do so.
I mean, I guess we could sit here and try to conjecture. I mean, maybe the people of the state could file a mandamus action against the General Assembly to do its job. Possibly we could change the criminal code so that the members of the General Assembly who vote for unbalanced budgets be thrown in jail. Maybe we could legalize for this brief purpose, possibly tarring, feathering, and running out of town the members of the General Assembly who won't vote for a balanced budget. I don't know the legality of that, but at least it's an option, something that we might want to consider going forward. Mr. Barclay, thank you for your fine legal work on this. It's clear that this is just yet more games from the other side. Again, it's total partisanship at this point. But again, thank you, Mr. Barclay, Mr. Newting, for sitting here and dealing with this trash coming from this General Assembly.
Mr. Martino.
Thank you, Speaker. And I do have a few questions. To the ladies who have joined with us, thank you for joining with us today. And I appreciate your comments and the impacts that you'll potentially see with any failure to bring forward a budget. We are on our last day. So I appreciate you coming in, sharing your stories and your concerns. Many of us share the same concerns. Mr. Newting, thank you for joining with us as well today. And I'm glad you are where you're at. I do respect your abilities, and I think that in the course of the whole administration, you bring at least some knowledge of state government to an administration who has a lot of federal people and folks that maybe do not have that interaction experience.
Thank you, sir.
Yeah, wish I was across the table from you. However, I do have some questions on the budget itself and some of the decisions. The personal services, with the budget that you were presented, one thing that could have been done is zeroing the budgets and leaving the personal services lines, and then you could be sure of paying the employees. I mean, that's an avenue that wasn't taken. But my question in these budgets is, why the vetoes of the non-GRF, of the items that fund the IDOT, the EPA, that puts a lot of potential collateral damage out there for people who really aren't impacted other than just bringing up the level of pressure for negotiations? That's something I did not understand, that I've done budgets as long as you have.
Yep. That's why it's an excellent question. We did look at that. As you can imagine, that would have been a very lengthy process, very convoluted. We did look at that, and as you know, Representative, Governor Rauner's directive to me has been to look at the budget in totality and not just deal only with general funds, but to look at other programs funded by other state services. And I think you've seen us do that not only in the governor's original budget proposal, but also in some of the management actions that have been announced over the last couple of weeks. So we really wanted to leave those things in play as we continued to discuss a budget with the legislature, and not let those things out as you might say, out the barn door.
And I understand negotiations for it, but when we're talking about, you got over $90 billion in spendings that the state does throughout all the other avenues. We control $32 billion of it. Of that, many people really are brought into play that shouldn't be in play. Road projects and things that are funded on their own. Other state funds, they're not impacted by sales, by income tax, by the primary driving forces of state government. Yeah. So for those people, and I had envisioned when you signed the education budget that you would come back and take the non-GRF items, because it takes part and parcel a large piece of Illinois out of the realm of collateral damage. They are no longer players in a massive power struggle, and it keeps the EPA going. It keeps the banks and regulations. It keeps those items. So with your decisions there, I do disagree, and I would hope that when the negotiations continue or go forward, those people don't have to be laid off, or their licenses don't have to stop, because it brings pressure to negotiation. I understand it, but we're now at that point where we've been with other administrations, where I would hope that you would consider, if we brought forward, and the members in this chamber would consider, if we brought forward an override of non-GRF, that those things could be brought forward so the people of Illinois could continue on their lives. So in those discussions, I would hope those would come up. So with the GRF and with the employees, or if we brought for the first time, and I don't know if you've seen it, but in 20 years I've never seen a personal services budget, a number that would do what the governor proposes to do, that your learned legal counsel, and I'm not a lawyer, may not be able to do if the courts decide we're wrong. We would then not be falsely building the hope of tens of thousands of Illinois' fine state employees and workers. So I would please ask you to put together a number which would be a personal services number, and I know you can do this, that would actually take care of what the administration would like to do if the courts bless it. So that would be my request of you.
Thank you, Representative.
Mr. Durkin.
Thank you, Mr. Speaker. I just have more of a House maintenance issue. I know earlier an inquiry was made by Representative Sullivan regarding our governor's liaisons who were not allowed onto the floor. They were told that that's no longer the case, but if you could instruct the doormen, if that is, they're still welcome, that they should be allowed inside the chamber, because I just spoke to one of the governor's liaisons who still is not being allowed access to the House chamber.
I'll have an inquiry with the Chief of Staff on this issue, sir, but when Mr. Barkley and Mr. Newting came in, they brought an entourage with them, and so there's only a certain number of people allowed on the floor. But I will certainly make the inquiry. No problem with me, but I don't make those rules.
No, I know, but there's plenty of room in the back, as over the past few months that they usually hang in the back of the chamber, and as you can tell, there's plenty of room, so I'm not worried about clutter.
Thank you, sir. Mr. Crespo.
Thank you, Speaker. Pam and Heather, thank you again for joining us, and thank you for being patient. Director Newting, thank you for joining us again. And a couple points I want to make. When we were presenting our budget bills, our spending plan, I made a statement on the House floor that we need to move the ball, the process forward. We're getting to a point where there were a lot of meetings. We had our own meetings as well, and it seems like nothing was coming out of those meetings. So we needed to start the process. And in a way, I'm glad we did, because that allowed the governor to have a budget bill for elementary and secondary education, which he signed. So the process did, in fact, produce something of value, because we had something in queue that he was able to sign and move the process forward. Also, that day when I was introducing my portion of the spending plan, a comment was made on the other side that they were going to file a bill to reflect the governor's spending priorities and his spending plan. Later on, the leader on that side came to the floor, because I kept asking the question, where's your bill? And the leader came out here to correct me and say, well, that he had filed a bill that reflected the governor's spending plan. You made a statement that the administration doesn't appropriate, but they, in turn, what they do is administrate. But he had an idea of what his spending plan was going to be like, and I know, that there are bills that were filed to reflect the governor's spending plan, correct?
That's my understanding, yes.
Okay, and I also know, in checking with staff, that there were no attempts or effort put in getting those bills out of committee. Granted, I'm pretty sure I'm going to hear from folks that the Democrats control that, but I do understand that there were no attempts, no requests to get those bills out of committee. But let me go back to the administration's spending plan. And I apologize, I don't have the bill numbers before me, but they're out there, they were filed. And again, so he does have, or the administration does have an idea how they want to spend the money, correct? Based on those bills that were filed.
We had proposals, we had meetings, we sat in meetings with you. I think they were good meetings, and we were along the path of working with you on a budget, yes.
Yeah. And again, we have those bill numbers. I apologize, I don't have the bill numbers. I'll try to get them later on and share them with you and in the House as well. But help me reconcile something, Director Newdy. So when our spending plan was put out there, we admitted that this was a spending plan. These were the priorities as this side saw them. And it did include some cuts, right? We included $400 million in Medicaid cuts. There were some other cuts. And it got to the point where we were like, okay, we're not sure what else we can cut. I still think we can cut some more. And I was hoping that we would work with the administration on doing that. But let's talk a bit about the bills that were filed that represent the administration's spending plan. You have to agree that that's out of balance by $2 or $3 billion, correct?
No, I don't agree with that. And those bills are irrelevant. They're in the graveyard of the Rules and Assignments Committee in the legislature with many other bills.
Well, but no attempts were made to bring him out of committee, number one. And obviously, we missed the deadlines to get bills through committee in the House floor. But those bills are out of balance by a little bit over $3 billion.
I disagree with that.
Okay, it factors in, and we've heard that the administration thinks that they're going to achieve $2.2 billion in savings from a pension reform. That's one of the assumptions built into the administration's budget.
Yeah, and we are ready, willing, and able to talk about other alternatives. Obviously, that was then, this is now. The landscape has changed. We continue to push for pension reform, and we continue to try and work with the legislature, the governor does, for pension reform. And I think you would agree, Representative, that really this budget is unsustainable if we don't do some sort of pension reform going forward. Over 20% of the state GRF in our current system is going to go to pay pension benefits. And that means less money for education and less money for human services and less money for every other priority of the members in this chamber because those expenses are so large.
And you know what? I'm not going to refute that. I'm in total agreement that we need to talk about the pension issue. We did that for several years, and we did pass a pension reform bill, which the courts struck has been unconstitutional. It's unfortunate that we haven't had that conversation. That was an important conversation that we should have had since January. For some reason, we're not talking about that. I think we're talking about this thing at a very high level, but that's a very significant piece of this budget, and we haven't been talking about that. We've been talking a lot about this turnaround agenda, but let me go back to the governor's spending plan, which again, we can see these, if I wish I had the bill numbers so I could be more specific, that again assumes a savings of $2.2 billion on pension reform, and we haven't had that conversation. And Director Newton, again, if you look at those bills, they're out of balance by over close to $3 billion. So how do we reconcile that with the spending plan that this side put together?
Again, Representative, I disagree. I think if we did pension reform, we could save money. There were aspects of the governor's original pension reform proposal that would not be characterized as questionable constitutionally. But let me comment, sir, because you did mention the turnaround agenda, and I've heard a lot of talk about how the budget's the most important thing, and the ideas that the governor has to structurally change the way business is done in this state are non-budget issues. As you know, the governor's agenda, whether it be workers' compensation reform, tort reform, unemployment insurance, property tax relief, are at their core designed to improve the state's economy by making us more competitive to bring more jobs to this state. And I would offer, sir, that the state's economy is the #1 budget issue in this state. It's what drives everything. When the economy is good, revenues are up. When the economy is bad, revenues are down. The economy is the #1 driver of state revenues, and that makes it the #1 budget issue. And any attempts to improve the state's economy through the governor's turnaround agenda is by definition unequivocally a budget issue.
Director Newton, I think I agree with most of what you said. Please help me understand, how does that turnaround agenda impact the fiscal year 16 budget? For the sake of discussion here, let's say tomorrow we went ahead with the turnaround agenda. How does that impact fiscal year 16's budget?
Okay. Again, at its core, the decision is what you want to do, respectfully, Representative, is continue with the status quo, which has failed this state. The governor, yes, sir, yeah, we have the lowest credit rating in the nation. We have the highest debt of almost any state in the country. We have huge backlogs of bills. What you want to do is just continue doing the same thing. The governor is saying we can't continue doing the same thing. We have to do things differently to improve the state's economy going forward. If we don't improve the state's economy, we have no hope of balancing budgets in the future. We have to get structural changes to put the state back on track, to grow the economy, and the revenues will take care of themselves.
Director Newton, I'm going to apologize. I think my action sometimes gets in the way. I'm going to repeat the question again. How does the turnaround agenda impact fiscal year 16 budget? I don't think you gave me an answer, but you didn't answer that question. How does that impact, again, the fiscal year 16 budget?
It will impact the economy with property taxes. It will free up resources at the local level. It definitely has an impact, and it's magnified going forward.
Director Newton, I have a lot of respect for you, but again, I don't think you answered my question. I understand you wanted to make a statement, and I appreciate that. Again, I'm not sure how the turnaround agenda impacts fiscal year 16. I'm not even sure how much it would generate in revenue. I haven't seen the assumptions yet. And I'll close with this. Again, for the record, you're telling this body that the administration's recommended spending plan is balanced.
We are ready to work with you on a balanced spending plan.
I know. Moving forward, I understand. But again, for the record, I think the first time I'm asking the question, this administration's spending plan is balanced, as presented in the bills that were introduced by the other side.
The spending plan that the governor is dealing with is the $4 billion out-of-balance plan that you put on his desk and he vetoed.
I understand. I'm going to ask a question for the last time. Is the governor's spending plan, as outlined in the bills that have been filed, Is that spending plan balanced?
Representative, respectfully, the spending plan that is on the table has been vetoed. We have an education budget, and we look forward to working with you on putting together a balanced budget.
Well, I think I can ask the question 10 times, Director Newting. I look forward to continue working with you and administration moving forward. I just hope that the line of communication is a little bit better. And Director Newting, let me tell you this, because we had an issue during the Good Friday massacre, as you recall. I was coming out of church. I get a call that some cuts were made, including cuts for autism programs. That was after we passed a supplemental bill, which I supported. One of very few folks on this side supported that supplemental bill. And we were under the impression that funding for mental health and disability services was going to remain intact. And the response, as I recall back then, was, oh, it was miscommunication. And I think we're having the same thing today, because I'm asking a question, I'm not getting the direct answers. I'm concerned by this communication issue. We have to communicate more, and we can't keep attributing this to miscommunication, because people will get hurt, and hopefully the communication will improve as well.
Thank you, sir.
That completes this panel. Before you leave, Ms. Eagleton and Ms. Luchtefeld, I know this last hour was excruciating for you, so we thank you very much for your attendance, and we're sorry you had to deal with this last little bit of time. Mr. Newting and Mr. Barkley, thank you for your attendance. You gentlemen are excused. Thank you very much. Panel number 2. First, let me assume that Director Demas and Director Holton are not here. Is that correct? I don't see them here. They're not here. The next witnesses are Amber Smock and Ann Ford from Access Living, along with a client, Adam Ballard. You may proceed when you're ready.
Thank you. My name is Ann Ford, and I'm the Executive Director of the Illinois Network of Centers for Independent Living. And I came to talk to you today about the impact that having no state budget will have on Centers for Independent Living. To give you a little background information, there are 22 Centers for Independent Living in Illinois throughout the state. They provide services in 93 of our counties. They're small. They are probably the smallest providers that contract with the Department of Human Services. They have one line item in the budget. It's a total of $4,600,000 for all 22 centers. In looking at what the impact would be for them, I reached out to the centers to get a sense of what their plans were starting tomorrow. And they're kind of all over the place, as you might expect. The centers vary from one place to another. Some are larger, some are smaller, some have been there longer, some are relatively new. Many different situations in terms of being able to secure other resources than their state funding. So each one is going to respond a little differently. Some of the ones I talked to were not even able to tell me yet because they're still having rather frantic meetings with their boards of directors to decide what they should do. Of the ones that I talked to, this is a sample of the information that I got. 2 of the centers will lay off staff as of July 1. So that's a total of 11 immediate layoffs. 4 centers will initiate furloughs July 1, impacting a total of 44 staff and resulting in reduced days of operation. 3 centers can maintain until mid-July, then will go to plans for layoffs and or furloughs. 1 center can maintain for 1 month, then will lay off over 20 people. 2 centers can maintain for 2 months, then will plan furloughs. 1 center can maintain for 3 months, then will plan layoffs. 3 centers have reserves that will allow them to maintain for longer periods of time, and they will revisit their planning each month. So that's kind of a sample of where they are. What I should tell you is the Centers for Independent Living statewide employ a total of about 350 people. So while these numbers I just read to you sound small, it's a big dent in the workforce for the services that Centers for Independent Living provide. The other thing that I think is important to know is that they all are looking at, number 1, not filling any positions that are currently vacant, and number 2, a great deal of insecurity because they don't know. They have received the paperwork for contracts for the coming year. They've been encouraged to sign and return the signature page in those contracts, but they lack the security to really think that when this is all over, those contracts will be in place. So it's really difficult to make these decisions. The centers serve statewide in direct services a total of just over 8,000 people a year. In addition to that, they provide information and referral services to over 54,000 people. It is not possible to say to you how many consumers will lose services because their programs are not defined in a way that puts people into slots. The services are individual. The services are geared toward providing people with the skills they need to be the ones in control of their own life and to be able to become self-sufficient and fully participating members of their society. So I will say again, while these numbers sound small, it would be devastating. And if this goes on for a long period of time, we would reach a point where fully 1/3 of the staff of centers would be either laid off or furloughed, which would have a devastating effect on everybody concerned. You know, we're often not on all the lists you look at because we are that small, but the work that's done is vital. The work that's done allows people to have lives that have meaning and be productive citizens of their communities. And I think that we need to understand the devastation that they will experience if the people they're relying on to guide them through a difficult time in their life suddenly are not there. Thank you.
raise it up a little bit. Okay, that's good. Good afternoon, Mr. Chairman, esteemed members of the House. My name is Adam Ballard, and I work at Access Living, the Center for Independent Living in Chicago. More importantly, I'm also a consumer in the Illinois Home Services Program, or HSP. This program serves about 30,000 people with disabilities ages 18 through 59 around the state, and I'm testifying today because we are concerned about the department's proposal to eliminate up to 10,000 people from that program, including myself, by raising eligibility under the Determination of Need score. So that's a concern. A more pressing concern in light of the looming shutdown is that all 30,000 of us are going to be put at risk as soon as tomorrow because we're still unsure if, or at least when, our home care workers who come into our home will be paid for the work they do starting tomorrow. I'm here today because, according to the U.S. Supreme Court in its Olmstead decision, I have the right to live at home. And that right is under attack, both in this budget crisis and in the looming shutdown. And this is the 25th anniversary of the Americans with Disabilities Act, the most sweeping civil rights legislation passed in this country since 1964. It's a bitter irony that I'm here with you today to defend my right to live independently in my own home with dignity as someone who depends on home services. My attendants arrive early every morning at my home in Westmont before the sun comes up to assist me in using the washroom, showering, and dressing. They help me brush my teeth, comb my hair, wash my glasses and face, applying facial cream so that I can be shiny and beautiful and start my day. After that, they help with a quick breakfast and or a cup of coffee if I have time, and then I rush to catch a rush hour train at the metro stop about 3 blocks from my house. This is all difficult, but it gives me a great deal of freedom. And indeed, my attendance services largely make it possible for me to be gainfully employed and a taxpayer. Can you imagine doing your jobs as legislators without the supports that I have if your mobility was impaired in the same way that mine is? I also have a family of my own, with 2 children with disabilities of their own who mean the world to me. Personal attendance services have been part of my life since I was a teenager. I couldn't have graduated college, started my family or my career without those supports. They've been part of my life for longer than they haven't been part of my life. And even if I wasn't working, my attendance services would prevent me from being warehoused in a nursing home or other institution that costs the state so much more than supporting me in the community costs, and would also take me away from my kids. However, the administration's proposed budget would make it harder to stay eligible for home services under the proposed change to the determination of need from 29 to 37. As of June 17th, my score is now a 31. Because of this budget, I am in imminent danger of losing those vital services. That would be devastating to me personally, as well as, again, the nearly 10,000 other consumers in the home services program who would lose services. In order to avoid losing my job and maybe even eventually returning to a nursing home, I'd have to rely on family and friends who are already stretched thin with other responsibilities, first and foremost helping to raise my 2 disabled children. I'd rely on them to provide me the assistance I need to bathe, dress, use the toilet, and just be ready for my day. That's not sustainable. It would represent a huge loss in the quality of life for me as well as my loved ones. Of course, raising the dawn for home-based programs also means raising it for nursing homes, so I wouldn't even be eligible right away for nursing home placement. Instead, I'd rely on my stretched thin support network. I'd watch my family fall apart. I'd be at risk of losing my job and then my home. And then finally, after my health deteriorated enough, I could possibly qualify for services again or institutional placement. That's not good for me, and it's not good for our state. I just want to continue to get the support I need to work, to stay in my home with my family. Isn't that what anyone in my position would want? And I can't have my hours cut any further either. I need support in the evenings and on weekends as well, but I have to be careful how I allocate my attendance hours to be sure that I have coverage on weekday mornings when my need is greatest. And now I have to worry about the shutdown. If the government begins to shut down tomorrow, will my attendance be paid, and if so, when? How can I be sure? What do I tell them? What happens to me and my ability to live and work independently if they're not? How can I ask my spouse and my family, already giving so much of themselves to help raise my kids, to do even more for me? How does that do anything but destroy what dignity my family and I have fought so hard to achieve? How is that anything resembling a shared sacrifice? And what about where I work? As the bills go unpaid, where does that leave the urgent work that only Access Living and our sister centers for independent living around the state can do? After we've used our reserves up, which, as you heard from Ann, is a different answer for each center, how do we decide which programs stop and which staff are laid off? When people leave nursing homes, and these are the people we're serving, providing an important service to the state and providing savings by moving these people into the community, when those people have no place to turn for housing or attendant care resources, do we just send them back? Or even worse, do we leave them on the streets? Access Living has been advised by the state that all of our contracts, except for our emergency personal attendant backup program, will continue for fiscal year 16. That's good news, but we have no assurances that we will be paid or when. And we are using our own revenues, our own reserves to pay for the next month of operations. But after that, it's not clear what we will have to do. What is clear to us at this time is that our state funding pays for up to 28 of our staff members. I know personally what living in a nursing home is like. I've already spent time in a nursing home due to rehabilitating 2 broken knees nearly 7 years ago. At the time, my youngest child was a newborn, and my eldest, who just turned 9 today, was just a toddler. And they had to come visit their daddy in a nursing home. They can't remember that time, but I'll never forget. I was only able to leave that place, which stripped me of dignity and self-determination, only because I had personal attendant services at my disposal. Removing 10,000 of us from this vital support will cost so much more down the road. And removing services tomorrow from all 30,000 of us is unimaginable. We've been on the right track in our state over the past few years when it comes to getting and keeping people out of institutions. Let's not throw it all away on incredibly short-sighted attempts at short-term savings. We need a long-term permanent revenue solution to balance our budget, not cut after cut after cut after cut. We don't want to come here every year and do this. And I just want to keep working and raising and supporting and enjoying time with my family. Thank you.
Thank you both for your testimony. It's appreciated. For Ann or Amber, have any state agencies provided you with direction in case there's no budget starting tomorrow?
This is Amber Small from Access Living. I'm going to defer to Ann first on that one.
Thank you. What my members have received are, as I said before, they did receive contracts to sign, the signature page and send back. They also did receive a letter from the Secretary of DHS that basically said they were asking that services continue, and it was their hope that the situation would be resolved soon, and that at that time, the expenses they had incurred would be covered. So they're going on kind of blind faith that if they stay open, which right this minute most of them are doing, beginning tomorrow, that at some point when there is a budget, they will be fully reimbursed under the contracts that they have signed, even though they have not received back a contract signed by the state.
You indicated that. Go ahead, Amber.
Yeah. Speaking for Access Living, we run several programs that utilize state funding, and the one program on which we've gotten a clear directive from the state at this time is the work that we do to help enforce the Colbert consent decree in Chicago. The Department of Aging made it clear that they want us to continue providing services under the Colbert consent decree to move people with disabilities out of nursing homes and into the community. The letter was not clear that funding would actually be in place to make this happen. However, there's now a court order in place to make sure that the funding does occur. But it shouldn't take court order to make sure that all funding continues for critical programs.
And so to either of you, you were told by this contract, in essence, to go ahead and keep providing services, but at what level? The level of funding that you were using in fiscal year 15?
The contracts that have been sent were written for the level of funding in 15. I believe there was a statement, and I cannot remember whether it was in the contract or in a separate document, that said that the total amount of funding might very well be changed depending on the budget that was passed. So that is also still up in the air.
And so if you don't know the level of funding, how do you provide the same level of service?
I think we're still trying to figure that out. What my members are doing is continuing the work they do, and I think the plan that most of them have is when the time comes, if they are notified that there's some cut to the budget, going forward they will have to make changes. But right now, so that their consumers are not disadvantaged, they're going to continue to provide the services they have been.
At the same level you were providing them previously?
Yes.
And is this, how does the 2.25% cut that came in April affect this? Was that contract that you received at the original level of the 2015 fiscal funding or with the cut?
The contracts were at the original level of the 2015 funding.
And you indicated that you received a signature page. Is that to infer that you did not receive an entire contract?
No, I'm sorry. I misstated that. We received entire contracts. The way the agency works is you receive the contract. It's online. You don't receive a paper contract. And you are asked to print out just the signature page to get it signed, scan it back in, and send it in so that the department has a signed signature page for each contract.
But you don't have anything back from the department yet, is that also correct?
No, because most of those were just received this week, so there's nothing back from the department.
But so as we sit here now, you have no formal commitment from the state of Illinois to fund your program, is that correct?
Other than the letter from the secretary that said it was their intention to fund it, and asking us to continue services.
Is that the word they used, intention?
I would have to look, honestly. I don't know. But that's what it implied.
So there was no direct statement in that letter saying, provide these services and you will be paid?
No. No, there was a statement that, as we all know, there is no budget right now, but they are asking us to continue because they believe there will be a budget eventually. And those are my words. I don't have a copy of that with me.
Oh, that's all right. And so if you compare the budget the governor introduced in February to the spending plan that was passed by the General Assembly, recently vetoed by the governor. Is there a difference in those two budgets relative to the line item that concerns you?
Not relative to our line item, but I would point out again, it's one of the very tiniest line items in the budget, and so it was not changed. The thing that did happen is that certain individual contracts, as Amber mentioned a minute ago, were eliminated. There were contracts that two of our centers had that had to do with providing backup personal assistance services for people in emergency situations. Those were eliminated both in the governor's budget introduced in February and the contracts that were sent out. My organization had a contract last year that was a training contract, and it was eliminated both in the governor's introduced budget and in the contracts that were sent out now. But the ones that were sent out, the amounts did not change.
And were those items eliminated? Go ahead, Amber.
I'm very sorry. I also want to point out that Centers for Independent Living also advocate on the home services program that serves 30,000 people with disabilities. The governor's original proposed budget called for a severe cut to that program. They were going to implement the Dawn score change. They were going to try to save over $100 million.